I think there are some member states who are still outside. I'll request them to please come in. We are going to start the session. Whether somebody could please close the gate so that we can start the session. Today, the first of the day, we have a special session on selected items on the agenda of the International Law Commission. I'll give the floor to the Secretary General now to introduce the panelists. Secretary General, you have the floor, please.
Thank you, Madam President. Excellencies, distinguished delegates, ladies and gentlemen, Sir Michael Wood, the distinguished member of the International Law Commission, Dr. Rohan Pereira, the chairman of the EPG and a former member of ILC. May I invite you all to the special half-day meeting on the topic selected item on the agenda of the International Law Commission. First and foremost, on behalf of the organization, I would like to pay tribute to the late Ambassador Chusi Yamada and to commemorate in grief his contribution in the field of international law as distinguished member of the ILC from Japan and as special rapporteur on the topic shared natural resources. The ALCO and the ILC has a long-standing mutual cooperation. Considering the importance of the work of ILC, the ALCO was statutorily mandated by its member states to follow and exchange the views of its member state on the agenda item of the ILC. Customarily, both the organizations mutually represent at their respective annual session. On behalf of ALCO, I had the opportunity to address this 65th session of the ILC. Since the ALCO's 52nd annual session was scheduled after the 65th session of the ILC, I had briefed the Commission about ALCO's comments and observation on specific agenda item of ILC on 9th July 2013. Excellencies, I have the privilege to invite Sir Michael Wood, a distinguished member of the ILC and the distinguished special rapporteur for the agenda item on customary international law, to this annual session. I look forward for Commission's message to ALCO on the work of the ILC. I also take this opportunity to introduce Mr. Narendra Singh, another distinguished member of the ILC from India, who has served as former president of ALCO and a panelist in this session, and Dr. Rohan Pereira, distinguished former member of ILC from Sri Lanka and currently the chairman of the Eminent Person Group, or EPG, of ALCO, to this special half-day meeting. Briefly, the deliberation at the 65th session of the Commission focused on 7 topics listed on the agenda of the ILC, namely, first, subsequent agreement and subsequent practice in relation to the interpretation of treaties; second, provisional application of treaties; third, most favored nation clause; and fourth, obligation to extradite or prosecute. With a view to have a focused deliberation on the work of the ILC, it was decided that this special meeting on selected item on the agenda of ILC will be on 3 important topics of ILC, namely, protection of persons in the event of disaster, immunity of state officials from foreign criminal jurisdiction, formation and evidence of customary international law. Madam President, Excellencies, ladies and gentlemen, the topic treaties over time was changed to subsequent agreements and subsequent practice in relation to the interpretation of treaties, and Mr. George Nolte, was appointed as the special rapporteur for this topic. The Commission considered the first report and dealt with, first, general rule and means of treaty interpretation, second, subsequent agreements and subsequent practice as means of interpretation, third, definition of subsequent agreement and subsequent practice as means of treaty interpretation, and fourth, attribution of treaty-related practice to a state. On provisional application of treaties, the Commission considered the memorandum of the Secretariat and the first report of the Special Rapporteur, Mr. Juan Manuel Gomez Robeldo. The report discussed the procedural history of the provisional application of treaties, raison d'etre of provisional application of treaties, shift from provisional entry into force to provisional application, legal basis for provisional application of part of a treaty, conditionality, juridical nature of provisional application, termination of provisional application. The focus of the study would be on Article 25 of the Vienna Convention on the Law of Treaties, 1969. The principal legal issues that arise in the context of the provisional application of treaties by virtue of doctrinal approaches to the topic would review the existing state practice. The study group on Most Favored Nation clause had before it a working paper entitled A Bit on Mixed Tribunal, Legal Character of Investment Dispute Settlement by Mr. Sinya Murase. The catalogue of the provision was prepared by Mr. Donald McRae and Dr. Rohan Pereira. The study group traced the contemporary practice and jurisprudence relevant to the interpretation of MFN clauses. In this connection, it had before it recent awards and dissenting and separate opinion addressing the issues under consideration by the study group. The report of the working group on obligation to extradite or prosecute consisted of detailed discussion of recent ICJ decision on obligation to extradite or prosecute in the Belgium versus Senegal case. The decision was helpful in elucidating basic elements of the obligation to extradite or prosecute to be included in national legislation, establishment of the necessary jurisdiction, obligation to investigate, obligation to prosecute, obligation to extradite, and consequences of non-compliance with the obligation to extradite or prosecute. Madam President, Excellencies, ladies and gentlemen, as mentioned earlier, this special meeting would be focusing on 3 agenda items: protection of person in the event of disaster, immunity of state officials from foreign criminal jurisdiction, and formation and evidence of customary international law. On protection of person in the event of disaster, the Commission considered the 6th report of the Special Rapporteur, Mr. Eduardo Valencia Ospina. The report discussed about the historical development of concept of disaster risk reduction, prevention as a principle of international law, tracing from human rights law and environmental law, international cooperation on prevention as dealt under bilateral and multilateral instrument, national policy and legislative framework on prevention, mitigation and preparedness, and proposal to include draft Article 16 on duty to prevent and draft Article 5 ter on cooperation for disaster risk reduction. As regard the topic immunity of state officials from foreign criminal jurisdiction, the Commission considered the 2nd report, which dealt with the scope of the topic and the draft articles, the concept of immunity and jurisdiction, the distinction between immunity rationale personae and immunity rationale materiae, and the normative elements of immunity rationale personae. Moreover, 3 draft Article 1, 3, and 4 on scope of the present draft articles, person enjoying immunity rationale personae, and the scope of immunity rationale personae was adopted by the Commission. Madam President, I need not mention at length on the topic on formation and evidence of customary international law, as we have Special Rapporteur Sir Michael Wood among us to enlighten us on this topic. However, I would like to precisely refer to this subject. There were two main documents which was considered by the Commission. First, the Memorandum of the Secretariat on elements in the previous work of the ILC that could be particularly relevant on the topic formation and evidence of customary evidence of international law, and second, first report of Special Rapporteur Mr. Michael Wood on this subject of formation and evidence of customary evidence of international law. The first report on the topic explains the scope and outcome of the topic, which addresses whether to cover jus cogent, customary international law as a source of international law under Article 38 of the Statute of ICJ, also refer to material that would be considered during the study, which focuses on, first, approach of states and other intergovernmental actors, second, case law of the International Court of Justice, third, case law of other courts, tribunals, fourth, work of other bodies, and fifth, writings. Finally, Madam President, on the comments of ALCO Secretariat on the subject. The concept of prevention as referred under protection of person in the event of disaster is definitive concept in international law and is a possible measure to reduce the disaster risk. However, pre-disaster preparedness, even at the presence of national legislation and authorities, would be very limited due to shortage of funding, disaster management, which remain a challenge for many of the developing countries. It would be more relevant to deal with technology transfer in terms of addressing post-disaster relief and rescue operation within the country. Indeed, ALCO Secretariat is of the view that duty to offer assistance, previously discussed in the fifth report on this subject, shall be not compulsory but voluntary, and should respect the principle of non-intervention in the internal affairs of the state by assistant offering state. With regard to the applicability of immunity rational personnel beyond Troika, there was a need to identify a clear criterion in establishing such practice, and also to consider the suggestion of enhancing cooperation between states in matters relating to invocation of immunity between the state, exercising jurisdiction, and the state of the official, in respect of the Troika as well as others. The view of ALCO Secretariat conforms to the view of the Special Rapporteur to the extent that in the absence of compelling arguments to the contrary, the status quo with regard to the extension of protection offered by immunity rational personnel being limited to the Troika be maintained. Finally, the topic formation and evidence of customary international law is very significant as far as ALCO members are concerned, because in order to derive the attitude of states and international organizations, material on state practice which has been requested by the rapporteur must be transmitted by the states. Those approaches and material would be very essential to evolve evidentiary practices on customary international law from the developing countries' perspective. Such comments and country position would contribute toward established state practices under international law. Further, it is the strong view of the ALCO Secretariat that the resolutions of international organizations, especially ALCO, should form part of customary international law. Moreover, the statement presented at forums such as ALCO depict the state practice which also be regarded as customary international law. I once again welcome all the panelists to this special meeting and look forward for a detailed discussions on these three subjects. I thank you very much, Madam President.
Thank you for introducing the subject. I'll now request Sir Michael Wood, who is member of the International Law Commission and Special Rapporteur for Formation and Evidence of Customary International Law, to make his presentation. So we'd like to go to the podium.
I think I'll sit here.
Okay.
Since I got my coffee.
Please.
General, Your Excellencies,